Does the Adam Walsh Act violate the Ex Post Facto clause of the United States Constitution? Section 9 of the United States Constitution specifically states, "No bill of attainder or ex post facto law shall be passed." Whenever a question arises concerning whether or not a new law violates the ex post facto clause of the United States Constitution, the Supreme Court of the United States consistently refers to one of its earliest decisions in Calder v. Bull, 3 U.S. 386 in the year 1798, where Justice Samuel Chase gave a detailed explanation of what exactly an ex post facto law is. To be specific, an ex post facto law is one that punishes a citizen for an innocent action, or in other words, for an act which when done was in violation of no existing law, a law that destroys or impairs the lawful private contracts of citizens, a law that makes a man a judge in his own cause, or a law that takes property from A and gives it to B. Justice Chase added, literally, it is only that a law shall not be passed concerning and after the fact, or thing done, or action committed. Applying the definition above in regard to sex offenses committed prior to the existence of any state or federal sex offender registration database works like this. Let's presume that the one and only offense took place in 1975, when there was no sex offender registration database of any kind. The violation of the law is an action committed, and due to the ex post facto clause of the United States Constitution and every state constitution, no legislative body can pass any law with regard to an action committed in the past. Because the federal government intends to retroactively apply a national registration database to all sex offenders, past and present, it is clearly attempting to pass a law that is after the fact, or thing done, or action committed, and is therefore unconstitutional. I think most people realize that the Adam Walsh Act is going to become widely accepted amongst the various states in the nation. However, this doesn't mean that we are forced to follow this law. In this country, we still have the right to protest, and no one in this country is forced to follow a law they believe to be unconstitutional. The reason for this is that an unconstitutional law is not law in this country. This is what Justice Chase has to say about such laws. An act of the legislature, for I cannot call it a law, contrary to the great first principles of the social compact, cannot be considered a rightful exercise of legislative authority. The term social compact here refers to the United States Constitution. There was a historical basis behind the prohibition of ex post facto laws in our country that had a lot to do with the King of England and the kind of government that he imposed upon his subjects. Our founding fathers didn't want anything like that happening here. Justice Chase gives us a little history lesson in regard to these issues. The prohibition against their making any ex post facto laws was introduced for greater caution, and very probably arose from the knowledge that the Parliament of Great Britain claimed and exercised a power to pass such laws, under the denomination of bills of attainder, or bills of pains and penalties, the first inflicting capital and the other less punishment. These acts were legislative judgments and an exercise of judicial power. Sometimes they respected the crime by declaring acts to be treason which were not treason when committed. At other times they violated the rules of evidence to supply a deficiency of legal proof, by admitting one witness when the existing law required two, by receiving evidence without oath, or the oath of the wife against the husband, or other testimony which the courts of justice would not admit at other times they inflicted punishments, where the party was not, by law, liable to any punishment, and in other cases they inflicted greater punishment than the law annexed to the offense. The ground for the exercise of such legislative power was this, that the safety of the kingdom depended upon the death or other punishment of the offender, as if traitors, when discovered, could be so formidable, or the government so insecure. With very few exceptions, the advocates of such laws were stimulated by ambition or personal resentment and vindictive malice. To prevent such and similar acts of violence and injustice, I believe the federal and state legislatures were prohibited from passing any bill of attainder or any ex post facto law. Bill of attainder is a term that we don't often hear anymore, and as a result most people don't know what it means. So to rectify this situation, the definition of a bill of attainder is a legislative act that singles out an individual or group for punishment without a trial. Now I think you can see the relationship that bills of attainder and ex post facto laws have with each other. When a person is taken to trial, he or she is subject to the laws that existed at the time of the trial. If, while a person is incarcerated, the law changes, and at a later date he or she obtains a new trial, the changes in the law that transpired while the person was incarcerated now come into play. But the only reason why they come into play is because it is a new trial. That is why the Adam Walsh Act is nothing more than a bill of attainder, because it is being applied to people when there is no new trial. And it is also an ex post facto law, because it is being applied retroactively. Here is the danger to all of this. Ex post facto laws create criminals with the stroke of a pen. They open the door for additional laws to be created that deprive groups of people and individuals of their freedom and their rights and protections afforded them by the United States Constitution. Once this door is open, the way is paved for every abuse of power conceivable.